Hi, everyone. Thank you for joining today's webinar presentation, The Future of Patent Prosecution, the Role of Patent Analytics in the Evolution of the Patent Prosecutor. I'm Allie Morton, Head of Field Marketing at LexisNexis Intellectual Property Solutions, and we have a really exciting webinar planned for you today. But first, I just need to cover a couple housekeeping things. During the webinar, please feel free to submit questions using the questions feature in the control panel. Also in the control panel, you will see a handouts section. This is where you can access the webinar slides from today's presentation, as well as other handouts. A follow-up email from today's presentation will be sent out later today. And now I'd like to introduce our presenters. With us today, we have Dr. Michael Sartori, a partner at Baker Botts' Intellectual Property Department. As a registered patent attorney, he focuses his practice on patent prosecution, patent portfolio counseling, and patent litigation. Prior to joining Baker Botts, Dr. Sartori served for over a decade as chair of the Patent Prosecution and Counseling Department at another AmLaw 100 firm. Also joining us today is Megan McLaughlin, the Director of Product Management at LexisNexis Intellectual Property Solutions. After graduating from Harvard Law School, she worked as a patent attorney at the law firm of Nutter, McLennan, and Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Megan.
Thanks, Allie. Thanks, everyone, for joining us today to talk about what's happening at the Patent Office and the data surrounding it and how we feel like that's changing the practice. So today, Michael's going to kick us off with some data about what's been happening at the Patent Office over the course of the past 10 years. And then we'll transition to a discussion about how that data is changing how we're able to practice as patent attorneys. We'll talk about specifically why the data quality matters. As with any statistics, looking at them in a different way can completely change what you see. And then finally, we'll talk about ways to objectively measure your own prosecution performance as a practitioner. So with that, I will go ahead and turn it over to Michael so he can give you guys an overview of what's been happening at the Patent Office for the past decade or so.
Hey, thanks, Megan. Sorry for that sun in my background here. It's this time of the day behind here. So anyway, it's kind of in the shadow. Sorry about that. So anyway, so thanks, Megan. I'm so sorry.
Actually,
okay.
on that note, if you guys do have questions, please feel free to enter them into the question section. We'll try to address them as we go if we can. If not, we'll hit them at the end.
Yep, that sounds good. Thanks, Megan. I appreciate that. So everybody, good afternoon for those on the East Coast, and good morning for those joining us from West Coast or elsewhere around the world. As Megan noted, we did this study here going back for 10 years. So patent procurement at the USPTO is affected by the type of examiner, as many of you perhaps may or may not know, or maybe joining us talk here today about the future of patent prosecution. So we at Baker Botts have been using the Patent Advisor database for some time, and we became curious as to whether the dynamics that we were seeing in the database were the same all the time, or they varied over time or changed by the examiner type or whatever else is going on. So we decided to undertake a study of the database by collecting and analyzing over a decade of data. And with the help of several folks here at Baker Botts, we gathered this data. It was a really intensive effort. We focused on eight non-design tech centers at the USPTO and disregard the design tech center because that kind of has some funky data that doesn't really correlate to the other ones. So we collected many metrics over the life cycle of the applications, and this is super intensive, a lot of work. So our results were published in a 4-part monthly series in Law 360 last summer, and also in a summary article published by IP Watchdog in January of this year, 2021. And these articles received a lot of attention. We got a lot of good feedback on them, and really happy to share this information with you. In fact, the first part of the series from Law 360 was announced to be the 5th most read article last year in Law 360. So really pretty proud of that, and also the attention that it gained, the popularity of what we're kind of doing and the message that we have here to share with you today. So using the LexisNexis Patent Advisor database, the number of green, yellow, and red examiners for each of the 8 non-design tech centers were gathered for the years 2009 to 2019. And this figure here up on the chart illustrates the percentage of green, yellow, and red examiners for each year for each of these 8 non-design tech centers, where the total for each year is 100%. So if you look at them vertically, each one of those little dots summed at 100%. And for the last several years, the split has been around a 45, 35, 20 for yellow, green, and red. And while the averages for yellow, green, and red over this decade plus are 44%, 37%, and 19%. And so what I really find fascinating about this data when we first pulled it up, I'm like, holy cow, is that this consistency of the percentage of each type of examiner over this period is really pretty the same. The red examiners are about the same, about 20% and 19% there on average. The green and yellow examiners are about the same for the last 5 years or so. So Megan, when you first saw this data that we talked about, what was your impression the same thing? You're like, holy cow, I can't believe it's the same, or what?
I was also shocked to see the lack of any change, particularly in the number of red examiners. I thought for sure around 2014 with Alice that we would have seen a rise in the number of red examiners, but it turns out no, that this seems to be independent of whatever is of any legal trends, of patent office management.
Yeah. We did see some of the Alice an Alice bump. I think one of the slides here shows a bit of the Alice bump in that time frame, 2014-15. Also, when the USPTO regs came out in 2019, kind of more positive for the applicant on those ones. In there.
But what's interesting, so yeah, I think there are trends in what they do, but in like overall, there is still the same number / percentage of examiners who take more time. Right. And the thing I'll mention here, for those of you who might not be familiar with the red, green, yellow terminology here, this is based on a metric called ETA, examiner time allocation. And what it is it's the ratio of the examiner's office actions to allowances across their portfolio. So red means the ratio is above 6, green means it's below 2.5, and yellow means between 2.5 and 6. So like a low ratio is good for us. fewer.
That's right. And that was probably a good precursor to mention there. So why is it red, yellow? How do you get red, yellow, green, Dr. Sartori? I don't know. No, because it's based on measurements. It's a proprietary unitless unbounded measure that LexisNexis has, and the lowest number is 0.1, and it goes up into kind of chunks. And there's some little squishy room around the edges, but that's how they kind of divide them into 3 parts. And I actually have friends, patent attorneys, that are not on the tech side, on the life sciences side, or the wet side, as one of my friends says. There's the wet side and the dry side. So those folks on the wet side, they like the fact the color part is very helpful to them, and not so numerical. So that's great. So and 3 is always a good number.
We didn't pull it out of a hat either. The ratio comes from some academic work by Dr. Shine too, from the University of West Virginia. He calls the ratio OGRE, office action to grant ratio, and he's found it to be very predictive of what happens in a case. But yeah, I think the ability here is what's so interesting.
It is, yeah. He actually did some great work. And if you haven't had a chance to read his articles, I highly recommend him. And he's been on some presentations with LexisNexis before, and he's got some really good research, really good results. I really recommend you tune in to, if it's more background on the information. It's really quite interesting. He did a great amount of work in this area. So Megan, you want to flip to the next slide there? So this figure illustrates the distributions of examiners across the 8 tech centers from the data we pulled. And for each tech center, the blue bar, which is on the right side of each tech center number, indicates the percentage of examiners overall in the tech center. So if you sum all those blue bars together, that equals 100%. And then for each tech center, the green, yellow, and red bars indicate the percentage of green, yellow, and red examiners in each tech center. And the green, yellow, and red bars for each tech center total 100%. So if you look at these, spend some time looking at this, you can see the Tech Center 2800, which is the third one from the right, has the most examiners, that has the highest blue bar, but also has the highest percentage of green examiners. So if you have an application that's pending with 2800, you have a great chance of getting a green examiner and getting some really good results from those applications. If you look at Tech Center 3600, which has a lot of the business method applications and inventions, that actually has the third most examiners. So that blue bar is the third highest, but it actually has the highest percentage of red examiners, and by quite a lot if you look at the other ones. If you kind of look at some of the other ones here, like the 1600, 1700, 21, 24, and 27, all those kind of have a really kind of similar pattern of about 50% or so yellow, 25, 30% green, and about 20% or so reds. It's really quite fascinating that actually that distribution, kind of falls out for each of those different. So some of the art units, five of the art units have really similar kind of percentages. Were you surprised with this, Megan, when you saw this for the first time?
No, but only because I've been looking at this data for a while. I think what is surprising is the fact that in every text space there's some distribution, right? There's no single text space where it's all one color. There are a couple of art units that are monochromatic. Yes. And specifically they're all red, and I think we all know what they are. I think it's 3689 and then some other one in 3600. I haven't found one that's all green yet, but I think what's interesting is that everywhere there is some distribution. Yeah. Yep. And good news to ask is that 2800 has the most examiners and also the most screen examiners. So,
yeah, I'm always happy when I have an application that's assigned to an examiner in 2800. I'm like, oh, this is going to be hopefully a good day for my client. So, but what's interesting about the Patent Advisor database too is that it does go down to the art unit, and you have some products which I think are really helpful. It talks about the distribution of the different art units. I think that was the pathways. We can predict the different where the application can be assigned, and that's a really helpful tool too, I think. So.
Yeah, that's where the practical implications of this data really come in. If you don't have any choice over where you're going, it's interesting but less helpful. But we find increasingly that people are able to have an influence on which technology space their application goes to. Like it started in the software, the people trying to avoid 3600, but I'm now starting to see it in a variety of different disciplines.
Right, yeah, we use it for the 3600 when we have software-based inventions. We use that product actually to help us try to avoid having the application assigned there. I think it's kind of like when you have a litigation, choosing the venue. You can kind of try to choose the art unit, kind of. It's the analogy that I like to tell my clients about how we use it. I think also we used it also for some of our continuation applications as well. The application's set in stone, so you can't change the spec much, but you can sometimes work with the claims and perhaps get a more favorable art unit, perhaps, for a different examiner as well too. So.
And do you find that you're able to actually do that on a continuation, not even a continuation in part? Are you able to change?
It depends. Sorry about that. It depends. Sometimes when I'm sorry, I've got people that call me. Okay, I'm so sorry, Megan. So embarrassed. So actually, so some applications, if the specification isn't very deep and it's just pretty high level, those ones are more difficult to do that. But if the specification is deep and has a lot of discussion, especially on the point of novelty and some different variations and doing that, that's very helpful. So when we write applications, we really try to put a lot of breadth into a discussion of those points of novelty and try to anticipate, where this thing could go. So I think a lot of patent attorneys do this, and it really makes a difference, especially if you're trying to squeeze into a different art unit at that point in the prosecution.
And do you find that clients are willing to pay this?
Sometimes if the invention's valuable enough, for sure. A lot of clients, a lot of companies like to rank their portfolios like A, B, C, D, or 1 through 5 and 1 through 3 sometimes, on the importance of the application. And for the importance of the application, they're willing to spend a little more to have it because maybe it's core to their products or services, and maybe it's a near-term one, or perhaps it's a competitor that they were trying to close out. And so it's really helpful, I think, in those ones are willing to pay for those ones. Not all the time, and not all the time that you want to use you need to use that, but those ones it's really helpful on.
Sure.
For sure. Yeah. That was kind of a segue off the tech center, but anyway, it's kind of fun. Let's see. Do you want to flip to the next slide there, Megan?
Let's
see. This is right. This is the right one. Yep, this is right. Yep. Percentage of patents allowed by examiner type. This one was really, when we pulled this data together initially, I was really kind of surprised by this one. So this figure illustrates the percentage of U.S. patents that each typed examiner issued over the time period, over this 2009 to 2019. So as you can see here, the percentage of all U.S. patents that were issued by green examiners is over 50% for the entire time period. It's kind of dragged down a little bit over recent years, and it's more than those issued by the yellow examiners and the red examiners. Over this time period, although the difference in the percentage of the US patents issued by the green and yellow examiners has narrowed, the average percentages are approximately 60% for green and 35% for yellow. In contrast, the percentage of US patents issued by red examiners has remained around 5%. So this figure really shows the dominance by green examiners over the time period in issuing patents, and is contrasted with the consistently low amounts of patents issued by red examiners. So combined with the prior data that we just showed two slides ago, on the percentage of the examiner types, green examiners, there's 37% green examiners, but they allow 60% of all patents. And the red examiners is about 19-20% of red examiners, but they only allow 5% of all the patents. So what this means is that there's a few examiners allowing many of the patents and many examiners allowing the few patents. And so we kind of coined a phrase in one of our other articles we talked about. It says few allowing many and many allowing few, and this is really the data that goes behind it. And so it really shows the dominance that green examiners have in terms of building out a company's portfolio or your client's portfolio, and how important it is to work with them and when you get one to be able to get a patent with them.
And this insight, this is why Patent Advisor was, because it's not just about technology. It's partially about technology. It's not about. There are red examiners everywhere, and if you get one of them, you can see that your chances of actually getting a patent decrease. I think the other really interesting thing we've gotten here is the convergence. The yellow. I wonder if in 5 to 10 years you're going to have 2 categories instead of 3.
Maybe part of our plan here is we're looking at this data again after 2021 and see what it looks like 2 years after we do this analysis and see if there's any changes here. I've looked at a little bit and I think it's about the same, but we'll wait till the final numbers come in for the year.
Do you have any feeling for if there's any kind of trend in terms of patent office management or in the law that could be causing this convergence? The examiners who were in the middle, kind of examiners at the top that are.
Yeah, this is really interesting. It's really kind of a macro trend. You know, something if you look at some of the different tech centers, they do have some variability, but it's really kind of really consistent on those numbers. It's really very, very odd. It's kind of the macro trend is really kind of converging. And it isn't, you can look at the different years. There's a few different directors here. We have the new one hopefully coming in sometime soon, and then we'll see what happens. And we're kind of in this, I guess, almost a year, I guess approaching a year now, maybe we haven't had an officially sanctioned director, but we'll see. So
yeah. I wonder how it is the U.S. Patent Office's attempt to bring a little bit more unity to the examination court, and to try and get everyone on the same page, because they're seeing this data too.
They are seeing they do, and they do attend our webinars too and read our articles. That's for sure. I've actually had some feedback from a number of them, so that's true. Yeah, they do pay attention. Yep.
Usually statistical interpretation.
Yeah.
And then change their training.
That's right.
But interesting, static, and those are obviously the causes that cause applicant community heartburn.
Right. I really apologize. There's sunlight behind me. I'm totally overshadowed here. I can't do anything about it. I'm sorry. So let's try this. Oh, this is awful. I'm sorry, Meg. Oh, that's a little better. How's that? Okay, there we go.
That's perfect.
Okay. Let's see. So let's do the allowance rate. Good. Okay, great. The allowance rate, right? So this figure illustrates the allowance rate for green, yellow, and red examiners, as well as all examiners combined, which is the blue line. As you can see, the allowance rate for the green examiners is higher than the average allowance rate, the blue line, while the allowance rate for the yellow and red examiners is consistently lower. And based on this data, the examiner type, you can see impacts an applicant's chances of obtaining a patent. The average allowance rate for all examiners is 70%, the blue line. And for the green examiners, it's 81%, yellow examiners 64%, and red is 38%. Comparing the green examiners and the red examiners over this time period, if an application is examined by a green examiner, the application is at least twice as likely as being allowed than if by a red examiner. That's really kind of an interesting result. This is an example of a doubling effect that we found in the data that between green examiners and red examiners. So this is when we talked about some of those inflections. So if you look there, there's actually an inflection in 2014 for the red examiners, and it's had kind of about a 10% dip after that, and that we believe that's kind of due to the Alice decision and its impact on Section 101 at the USPTO. And then 2019, you kind of see there's an uptick there, and we believe about 10% uptick. We believe that's attributable to the 2019 Section 101 guidelines issued by the USPTO. So we kind of, in our view, those kind of things have actually, you can see those things in the red examiners. They don't really appear that much in the green, not at all. In the red, yellow maybe a little bit, but for the red for sure, those are impacting ones. I think that's where the positive effect came out on those, especially the 2019 guidelines. I know we were happy to see them, and a lot of our clients were as well too. So.
Yeah, and I think the interesting trend to point out is still generally upward. So just looking at, again, macro trends at the office for the past 10 years, everything's moving in a bit of an applicant trend. I'm going to, there's an echo on my end too. But yeah, in terms of time to allowance, office actions to allowance, we're seeing everything just get slightly more applicant favorable over the past 10 years. And it's hard to tell whether that trend is continuing, but I think it is.
Okay, so the data we looked at not only the allowance rate, but we looked at a lot of different metrics over the life cycle of a patent application, and did the comparisons. And you can see the data we have published in those different articles. But the next slide here, Megan, this one actually summarizes the comparison between the green examiners and red examiners. We found really compelling that it's at least a doubling of effort involved. So if you can look at these two green and red examiners across all these different metrics, it really shows a great difference in the amount of effort that is required when an application is examined by a green examiner versus a red examiner. And this difference is at least a doubling effect, and it results in terms of cost savings, or cost expenditure, timing, effort. It's just a lot. So for example, if comparing green and red examiners, if you have a red examiner, the allowance rate is cut in half. You have twice as many office actions. The application will take twice as long to examine. You will have twice as many applications with at least one final office action, at least 4 times as many applications with 2 final office actions, 50% more restrictions, and twice as many interviews. Also, looking at some after final practice, allowance rate immediately after final amendment is cut by 1/3. You'll have 3 times as many AFCP 2.0s, twice as many with at least 1 RCE, twice as many with 2 or more RCEs. The allowance rate immediately after the RCE is also a quarter. And the time next action is 50% higher. This kind of go on here. This is just a summary of them. I don't want to talk about them all, but it's really amazing. If you look at it, you're like, wow, it does make a difference. It is impacted. It's not just a green, yellow, red. It's, oh, it'll take me a little bit longer. But no, every aspect, every metric we looked at, there's a total impact total impact from the examiner type. We were surprised with this, and so because of this, we really use this all the time. Honestly, we use it all the time. And once I talk to clients and our friends about this, it's like, yeah, we should be using that too. So
yeah, I think that's a perfect transition to the next phase, where I'd just like to talk a little bit about how knowing this data has changed your practice, right? So what hasn't really changed is the makeup of examiners at the patent office and how they operate. That's with some minor, fluctuations. That's been fairly consistent over the past decade. So I'd like to talk about how just knowing this, I mean, it's hard to imagine how seeing this data could not change the practice. And I want to talk a little bit about the specific ways it does. But before we jump into that, I want to ask the audience a quick poll, because I'd be interested to know how many people out there are actually using these types of analytics to make prosecution decisions right now. Like I said, I can't imagine that it would not make a difference to see this kind of data. So I'd be interested to see how often people are using these analytics. Almost all the time, most of the time, some of the time, very infrequently, or never.
Well, Megan, you know my answer, but I can't vote. So.
Well, and this is, yeah, I'm excited to talk to you about how it is changing your practice. So it looks like the results coming in, a majority are still not using these analytics, but close second some of the time, and then every once in a while. It looks like people are using this data. So it's getting out there. You know, when I moved over to Lexis 5 years ago, it never occurred to any of us to look at examiner analytics before we made a decision. It was all entirely based on the facts of the case and our own subjective judgment and expertise. So this is still, I think, something that is brand new. So Michael, I want to ask you, now that this data is available, you're using it in your practice, what are the top ways you feel like your practice has changed?
You know, as you know, I've been practicing in the field for a while. I was actually a former patent examiner too, and for about 3 years, and then went to law school in the evening at Georgetown. So I kind of been with the patent office and been in this field for a while. I'd say 25 years, I think, practicing. So you know, before I really was introduced to the analytics here, and as I've talked to other folks who've been practicing, you know, for 15, 20 years plus, you kind of have a gut feeling for it, you know, and so you kind of feel. It's really kind of gut-based, kind of on what's going on here. I'm sorry, just lost my train of thought. Anyway, so it's anyway, so you kind of, you know, just wouldn't work with it. You wouldn't really. In fact, I'm sorry. What I would say was that some of my clients and some clients you work with particular art unit a lot, and so you kind of get a feel for who the examiners are, and so you have in your mind kind of who those examiners are and what their trends are, but you don't have the data to back it up. And with the examiner analytics, you really have that data to back it up. Or if you maybe have a client or you're filing in areas all over the place, you don't really know who the examiners are. And so what this does is it helps you with that gut and kind of how it's going. And so initially when I saw the data, Megan, I was using it, you know, started kind of sampling it, saying, you know, how does it impact? What do you think we should do? But now that I've become really familiar with it, we use it all the time. So if we have a case, for example, if we have a case that's like really important, we'll look at it as soon as the examiner is assigned to it, and we'll see if it's a green, yellow, red examiner, and look at, you know, it'll be like the 1 or the A type of case for the client, for our client, and we'll go ahead and put a plan in place on how we're gonna handle it. And if not so important, then maybe at least when we get the first office action, we'll pull the data right away. And as we prepare, you know, our recommendations on how to respond, we'll roll right into the statistics and say, hey, you know, this looks like a tough examiner. It's an easy examiner. We know this is an important case, not an important case. You know, we showed some macro trends here, but the data that you have in the database with the patent advisor is granular at the examiner level. You can see exactly what the examiner is doing. And so it's so powerful. I can't imagine actually not using it, you know, in my practice.
Yeah.
Honestly, I can't.
So,
I hope you guys love it.
Well, this is really interesting to me because you are an experienced attorney, and you know, when you first saw this data, you've been practicing for years, and you did have these gut feels. But nonetheless, it seems like it's valuable just because it gets everyone on the same page in terms of expectations. Because so when I first saw this data, I left the practice as an associate, and I'll never forget. I had a conversation with a partner right when I first started practicing, and he said, he was a very straightforward guy. He's like, look, you have one job. That's to add value to my life and to my practice. And you know what? That's actually really hard to do as a young associate, because you come in and you're working with these people who've been doing this exact very niche thing for 30, 40 years even, and you're somehow supposed to add value. But had I had this data, I think it would have been able to add value. So it's nice to hear from a very experienced practitioner that even still, it can add value to your practice just by helping to set expectations and by validating that gut feel that you already had.
It is, you know, and even for, you know, some of the larger portfolios we handle, you know, for our clients, you know, they understand this, you know, we're involved with them, they understand we're using the data and they do it. But even for our smaller ones that, you know, where, you know, they're not in the patent field a lot, maybe they don't have any in-house counsel, they're relying on us to really provide that information. Those ones, it's really helpful because you say, well, everything kind of gets rejected, you're going to have a good chance, and we kind of say, okay, here's the stats of this examiner. And it's data driven, and data driven decision making is really kind of seeping into our society in a lot of ways. And I like this a lot because a lot of data driven decision making is done on the business end, and this really kind of validates this stuff. And what actually some of our, we have actually 2 software clients that are into big data analytics, and they love this. because that's their business.
Yeah.
Their business is data driven. So the fact that we're using it also for our practice, they think it's really cool, you know, and they buy into it. I'm just playing with the sunlight here. They really buy into it as well.
Yeah.
Too.
Yeah, so I'm gonna ask a very specific question. So if I could have one takeaway from looking at the data over time, it would be that appeal is a very valuable option. Even just filing a notice of appeal, you know, to kind of as a strategy move to kind of prove that you're serious. Does having the data on appeals help when you need to make that decision, and if so, how?
It does. That's a good point because you know there's one appeal stat which is, you know, will you win on appeal or not on appeal, and that's a good stat. But a lot of companies don't want to take the time. There's also the stat you have on how long will it have to how long we have to wait to get a decision from the PTAB. That sometimes is maybe too long. The product cycle is too long, or they just need a patent sooner, and this maybe abandon instead of doing it. But the way you have the data broken out, you can do, you know, you can file an AFCP 2.0, you can do an amendment after final, you can do, you know, different things, and see how it goes. And so the data is there to say, so maybe you don't do a full appeal brief, maybe you do one of those other things that maybe it's a little short one. You can see the results, the chances of having success with that examiner are there as well in the appeal cycle. It's really quite amazing. It's really pretty granular on those decisions. I think you guys have done a good job on breaking those out and kind of parsing it for the practitioners.
Yeah. So it seems like it definitely helps to support decisions that you were making and to help provide the same type of advice you already did. Are there situations where you feel like it's helping you to provide new and different kinds of counsel? And specifically, this is relating to the conversation, so you're not wondering what I'm talking about. This is related to the conversation we had earlier about, you know, situations where clients have filing targets every year. So does it help with that?
It helps us maintain the filing targets.
Yeah.
Yeah, I think so. Yeah, because I mean this because we have clients that do have filing targets. I have are you trying to bridge my new articles I put out? You trying to make it a bridge me there?
Maybe.
Maybe right. So thanks, Megan. So we this past summer actually did a series of articles. I think some of you may have seen it also published on Law 360 on a theoretical filing target. So how many patent applications should you file a year? And some is kind of a toss of a coin, or kind of make, you know, what kind of walks in the door, or it's kind of based on how much budget you have. But we came up with we use some other folks working kind of expanded it a bit, but you can, based on kind of the industry sector of your company and how much R&D spend you have, you can go ahead and predict or get a theoretical number on how many applications you should file. And on the I think on the end of the handouts here, we have a link to some of those articles. But it's really pretty fascinating here. And so we use it kind of as, we have a couple of things we're doing for data driven. What we really try to do, we're trying to go for cost efficient, high quality, data driven patent prosecution. And so patent examiner analytics is part of it, but also how many applications should you file as well each year? Are you on target compared to your competitors? Are you scraping off enough applications given how much money your company is spending on R&D? Those are really important questions to ask, you know. And then and so part of that too, we're using examiner analytics with that to say, okay, can we go ahead and bolster our portfolio by building the families out for maybe examiners that we have, green examiners, where we're getting some very favorable results. We have some good claim scope, reasonably good claim scope, not overly broad, but good claim scope, and that we want to go ahead and build that out. So we can use those hand in hand to do that.
Yeah. So it seems like you can be more of an overall portfolio advisor.
Yep.
In a different way, not just giving advice on a particular application.
Yep.
You know, the last trend I kind of wanted to ask you about, we all know that filing timelines are really tight now. Seems like, well, first there's more pressure to file right away, obviously, but also it seems like over the course of the past 10, 20 years with fixed fees, you know, there's pressure to write applications faster, write responses faster. How does this data and analytics help you in that space, if at all?
Let's see, I'll switch over here maybe. Oh, almost the sun's that far. Hey, how about there? Okay, cool. Maybe. Sorry. I think data analytics is awesome. We use it for we use it for writing applications as well too, in that aspect of it. You have the product, the
Patent Optimizer.
Patent Optimizer, right? Patent Optimizer, right? Where you can help drafting applications too, and that's another one as well too. But we use that as well too. And we're on that product. It is it helps you kind of avoid the formalities objections, like the 112 issues, the objections, helps you find support in the claims. And so what I like about that is it increases our timing cycle on how fast we write applications. It's not as many edits to come through it because the software is actually helping our agents and our attorneys write those applications up for us. And so I use it. It matches the reference numbers to the figures, which I think is wonderful. Checks for typos between those two, looks for antecedent basis within the claims, but also with the claims and with the spec. And so we use it as a way to improve our quality quickly, but also I use it as for training folks. I'm training a lot of attorneys over my career, and it's really helpful. I can focus more on the larger concepts we're trying to achieve for the client's goals and just drafting style, but it helps to pick up those things. I also like there's a dictionary list of words you shouldn't use, and that's really helpful as well.
Okay. Yeah, no, I like that. I like the idea of using it for training to take more time so you can do your work.
Yep.
So having heard Michael talk about this, I want to submit another poll question to the audience. And really it's so we know that a lot of people aren't using these statistics yet. So what I want to hear from you guys is, do you think that you could improve your prosecution outcomes if you considered examiner analytics in your strategy decisions? And some of this is obviously getting patents faster, fewer office actions, but some of this is also like Michael said about improving the relationship with the client. So everybody or any stakeholder in the patent prosecution process, to make sure that everyone's on the same page about what's about to happen. So it sounds like at 80%, a strong majority either agree or somewhat agree that this could help. And yeah, that makes sense to me. It's hard for me to imagine how the data wouldn't help, particularly in light of the extreme variability that we do see in terms of outcomes at the patent office. If you've got someone who's only likely to issue a few patents per year and you just got your application assigned to them, it seems impossible that you wouldn't know this. So the last question I have for you, Michael, before moving on to the next section about prosecution metrics for law firms and corporations. The funny thing about statistics and data is that if you're not careful, it can say anything you want it to say. And there's also, obviously, you want to make sure that it's accurate. So how do you feel about the data quality and how important that is?
The data quality is very important for sure. So we're basing our advice to our counsel on it, and I think our advice to our clients is based on the data. We're relying on the data here to give advice. And I think, in my view, the patent advisor database, I think, is very powerful because it does have the LexisNexis behind us. I trust the data. There's some other databases out there. I'm like, I don't know. Some ones that are kind of on the line or free or whatever. We have a paid subscription to LexisNexis Patent Advisor. I like it. I'm an advocate for it. I have this little post note here about that. It's kind of weird.
Yeah.
So yeah, but I think it's great. I think the data consistency is good. I think also the constant update that is in the database is good. I know that when we look at maybe a case, right away, and maybe 6 or 8 months later, another office action, sometimes the data on the examiner's changed. It's not a lot, but it's there. It's very consistent. Right. One thing I want to mention too, also, Megan, we like also is that the patent office does have has some turnover in the examiners, and there's some our units have a lot of new examiners, seems like all the time. And so how do you handle those? And so we actually use the statistics from the art unit to help us out on those ones. And not because the examiner ones are just there's just not enough data to have any really meaningful results. So we kind of use that as well too. And I think that because those ones, the data that you take for those is really helpful as well too. I like it a lot too.
Yeah, it's tough with the new examiners. And one interesting thing we notice is that almost immediately when they start, they get a giant docket of cases. Like I've seen brand new examiners that have like 80 pending cases on their docket. like I can imagine as an attorney having 80 cases on my docket, that would be a lot. I'm pretty sure it took me years to build up to anywhere close to 100.
Yeah, hopefully not all the same by week.
Yeah, so you can imagine it's taken them a long time just to get to the bottom of that.
Yeah.
When they're new. So yeah, speaking of data quality, I will say, as somebody who processes this data every day, by far the hardest thing of patent office data is trying to figure out which law firm is working on the case. That is tricky. And that kind of leads us into what I want to talk about next, which is being able to, as a patent practitioner, as a patent applicant, being able to measure your own prosecution performance in light of the examiner variability that we've seen here. So to kick us off with that section, I'm going to ask you guys one more question. And that is whether you have asked for, or whether you've been asked for, prosecution analytics to demonstrate your own performance. So whether someone came to you and said, hey, what's your allowance rate? Or how many office actions on average is it taking you to get patent? Because I can tell you, 5 years ago, nobody was asking these questions because the data was just not available. But yeah, this is interesting. So we're seeing about 20% saying, yeah, they've either asked for this data or they've been asked for this data, which I think is pretty shocking when, again, you consider 5-10 years ago, this wasn't available at all. So here's what I'll say about that. So there are a lot of rankings out there. I'm sure if I Googled it today, who are the top 10 law firms doing X? I'd probably get a list of the top 10 law firms that are the biggest that have, like an allowance rate over 80 or something like that. But here's my problem with that. Allowance rate doesn't mean a whole heck of a lot for a law firm, right? I mean, Michael, you can speak to this. How often do you actually get to decide whether to abandon a case versus your clients deciding that?
It's the client's decision to move forward or abandon. We can recommend one or the other. And actually we use the statistics to help clarify that crystal ball. So this is red examiner, it's low allowance rate, chance of appeal is low. We should probably move that budget someplace else.
Yeah. So you advise them, but it's their choice, right?
It's their choice. It's their choice.
Right. So, I mean, and again, like you probably have more clout when you say that. I remember advising clients to abandon and it didn't work at all. So when I see law firm allowance rates, I'm immediately like, I don't know about this. And then here's the other reason, which is that it depends on which examiner you got, right? Maybe like you're a firm that works in software. You're always in 3600. So just as a concrete example, here's a case. An example case that was filed in 2016. It was issued in 3 years, 3 office actions, and 1 RCE. If this were with an examiner with an 80% allowance rate, average 1.5 office actions to allowance, I'd say this is not that great. Like, you probably could have done better with this. What went wrong? Mm-hmm. Whereas if this is in the 3600s with some examiner with a 20% allowance rate, I'd say, whoa, way to go. This is fantastic. So whenever you're looking at a law firm, I think it's crucial to account for that examiner variability that we just saw. So we created a metric called the Patent Advisor Efficiency Score, and it's basically that. What we do is we look at every single application in a firm's portfolio, and we give it a score of 0 to 100, and 50 is the average. If the attorney was able to bring the case to resolution, and resolution can be abandonment or patenting. We don't discriminate. There's no penalty for abandoning cases because we recognize that sometimes that's the best move. But if it was brought to resolution above average time, we'll give it a score above 50. If it was brought to resolution below average, we'll give it a score below 50. And then the overall average of all the scores for the applications is that firm's efficiency score. And what's interesting, I'll tell you, is most big law firms are between 40 and 60. Small range. The majority of variability that's coming out of the prosecution process is coming from the examiners, not from the law firms. I wish I could show you a nice distribution of that. I don't have one on hand, but the vast majority, probably 80 to 90%, are in a very narrow range in the middle. So here's just an example of how we would do this. Oh, sorry.
Sorry to interrupt, but your slides aren't showing anymore.
Oh, they're not. Interesting. Let me see. Is it back?
There you go.
Okay, sorry, I don't know what I did. So just to give you a concrete example of what this looks like. So here's an application. Of course, I picked a horrendous example, 9 office actions and 4 RCEs. Who knows what happened here? I don't judge. It happens to all of us. But if we were looking at this case, we would not give it a good score. So the examiner, on average, it only takes 3.3 office actions and 1 RCE to get a patent, and this went way, way beyond. So this application is going to get a score way below 50. And then that's kind of how we go through the process. We apply a score to every application in the portfolio and then average the scores. And then the average score for all applications is the total efficiency score. Here's why this matters. So this is just an example analysis that we did in the text base for AI. So we specifically looked at Tech Center Group 2120, which has a lot of the AI stuff at the patent office, not everything, but this is the art unit that's actually named AI, where a lot of it's supposed to go. And we looked at the top 5 filers from these different geographies. And we looked at their allowance rates, that's your y-axis. And we looked at the time to allowance, which is the x-axis. So we're kind of looking at a combination of effectiveness here on the y-axis and efficiency here on the x-axis. So you want to be in the upper right-hand corner, basically. That means you're getting patents effectively and efficiently. And what we found is the U.S. is, of course, the biggest filer. It's the U.S. And they're nicely squarely here in the green zone. But Asia, even though they don't have the highest allowance rate, they're at least efficient. They're not getting as many patents, but they're also not spending as much money as, for example, the European applicants. But here's where this gets interesting. So now let's apply the Patent Advisor Efficiency Score. So take examiner variability out of the equation, and all of a sudden it changes. So now suddenly the U.S. isn't above average anymore. Only Asia is above average in terms of efficiency now. So what this tells me is that whichever particular applicants were filing in the U.S. happens to end up with more green examiners than the applicants that were filing in from other countries. This is probably chance, but nonetheless, you can see how it impacts the outcomes. And this is why I think it's so important to normalize for examiner difficulty. You know, we talked to, it seems like in the audience, about 20% of people have either had to provide these kinds of statistics or have asked for them. I guess anecdotally, I don't know a single major corporation that's not looking somehow at what their law firms are doing and looking at how they're performing with respect to others. So as these statistics get more and more common, I think it's really important that we keep in mind the slides that Michael showed us in the first half of the presentation, which is that the examiner that you get has a huge impact on your prosecution outcomes. So the last point that I'll make here before I open it up to the floor for any questions or for final thoughts, we know that it's hard to include this data in your workflow. A lot of you out there are billing in 6-minute increments. And so what we've done is we actually created a browser extension recently that injects the data directly into PAIR. So as soon as you pull up that application in public PAIR, private PAIR, the new data center, the data is there right for you. You don't have to go some separate place to get it. And we hope that this helps to make a difference because, and Michael, you can tell me whether you think this is true or not, but one thing I hear a lot is that a lot of people don't look at this data until they're stuck in prosecution. And again, no judgment. I mean, like it's, you know, prosecution from the data does go smoothly a majority of the time. And so a lot of people wait till they're stuck. And if I could give one piece of advice from looking at the data over the course of the past 6 years, it's that a lot of people could benefit from first just knowing that you're with a red examiner from day one, and then trying to appeal or abandon early before you're 10 office actions in, then you realize that you have a problem.
Megan, that is so true, and that's why we look at the data up front right away. Like I said, even before the first office action for some cases, or for all at the first office action for every other case. It's just so important. It helps us guide the application to a favorable outcome as best we can. Like I said earlier, you know, a lot of companies have fixed budgets. You know, you have a fixed budget for prosecution. You know, and it's a bucket that includes, you know, foreign filing, U.S. filing, new applications, prosecution, maintenance fees sometimes. You know, so how are you going to divide that thing up, and what's the best way to do that? And so if you can reallocate a portion of that fixed budget to an area that's going to have a better outcome, perhaps new applications or a better future, then you should do that. And so we help these analytics actually help to prune the portfolio in the prosecution stages before it gets out to 10 applications. So maybe if it's a red examiner that's a really red examiner, and you have a case that's kind of a C/D grade case, not so important, you're like, okay, let's roll the dice maybe on one off section, see what happens, and just forget it, cut it off, and go forward. I was talking to one company earlier this year on this data, and they had a policy of they were going to file one RCE on every application. They just didn't care. They could file one RCE. I'm like, why are you doing that? You should look at this stuff ahead of time. And we talked about this, and actually they've changed their policy because of the examiner analytics, and so they can avoid spending that one RCE, and it can take them to a different place perhaps, and put that money someplace else where it's better used in the budget. That's really powerful. I think it's a way to, like I said, to have cost conscious, high quality, data driven patent portfolios. I think this is really a key component in hitting that goal for us.
Yeah.
So one thing too, I think I want to mention also is that we talked about this, I think last year. So I think either late last year or early this year, Megan, you guys put the interview statistics in the database. Remember those? Right. And so I found those are very helpful. And so you have the basic allowance rate, and then you have the allowance rate if you interview the case and don't interview the case. And it's actually quite amazing. It's whether or not you have one interview or not. And some you'll find in there is that some examiners don't respond well to interviews, and some do. And so if it's a case that perhaps is on the fence, you want to maybe interview that case for sure. Some companies I've talked to said they want to interview every case. Some say they don't want to interview any case. And I'm like, well, it's kind of maybe someplace in the middle. And so I think these statistics are really helpful. To help make that decision on when to do it and kind of if you should do it. Because interviewing, that does increase the cost per application in your budget. Is it worth it or not? And some companies like, we're not doing interviews. It costs much money. Well, in this case, it could be really helpful.
I think that's a really important point, because I think a lot of people can just assume that they're going to do an interview every time, because when would an interview not help? And to be sure, the data on interviews is really favorable, but not always. So sometimes with some examiners, it doesn't look like it's really moving prosecution forward.
Right.
It's just an extra cost. But to the value of the interview data, the other thing that I've heard a lot is a lot of people think it's the most valuable piece of data that we provide, because it gives an indication of the examiner's reasonableness. So if they're a person that you can get on the phone and talk to, and then have a really good outcome, that's a good indication that this person is willing to work with you. So yeah, I'm glad you mentioned that, because I've heard a lot that's kind of a top statistic that people like to look at.
It is, and I think what the data allows us to do is to avoid rigorous rules on how to prosecute a case. Always an RCE, no interviews. It's just very regimented, and I don't really like that. I like to be more flexible with that. And the data allows us to have a data-driven decision making to say, okay, what are we going to do in this case here? And so we have kind of a playbook that we go with, on what comes up and where, and how to manage our portfolios based on what we're seeing in the data. We found it really. I don't have any statistics to show that it works, but my gut is going back to the gut feeling, Megan, is that it really works. I think we feel get a better outcome faster, less cost for our clients, than if we wouldn't do it. And I just really believe in it a lot. I think it's really important to do these ones for our clients.
Yeah, well, and it seems like the clients then at least know what the situation is. So even if the data, because I'll tell you too, there are times where I'll look at the data for a case, and I mean, it's just bad. Like, as a red examiner, there's low chance of success on appeal. They don't do well with interview. Like, just what do you do? But at least at that point, everyone's on the same page about it, and then you can make an informed decision moving forward. So just a couple questions. What are the top pieces, what are the top statistics that you look for in an examiner? So obviously you're looking at the interview statistics. Are there statistics you look at every time? And if so, what are those?
Let's see, every time. We look at a lot. I like you guys have a lot, and it kind of depends on kind of where it's going, but we like to look at things like, how experienced is the examiner, what's the chance of receiving a patent, how long will it take to receive a patent, how many likely office actions will there be, how many RCEs, and putting that all in the pot with the case relevance, for the client as well too. How important is this case to you, to your business directors? We try to give legal advice that's business focused, so we're trying to drive the legal solution to the business solution, and this is very helpful in helping us to drive towards that goal. The goal is, what do you want to do with this patent? Let us help you get there.
Right.
And so the data helps us to inform that decision as well. So I think all the after final data. I think I've actually done a number of webinars on and given written papers on after final practice. It's really I tend to get a lot of interest in those ones, Megan. And so I think because it is somewhat arcane in some sense, there are some different options in there, and I think a lot of practitioners, especially early in their careers, have it's really kind of amorphous, and what do you kind of do? And so the data there I think is really helpful. After final on kind of how do you go about making those decisions, to get the best outcome for your client as possible.
Right. Yeah, that makes sense. And then we had another question in here about other patent offices. Right now, Patent Advisor only has U.S. PTO data. So I can't tell you anything about the other patent offices right now or how they rate, but maybe someday. So with the last few minutes, Michael, what final thoughts do you want to leave? What do you want to be the audience's takeaway from today?
That's a good question. Let's see. I lost my thing. Right. So I think for me, Megan, I think people, when I get these talks, like, Dr. Sartre, what do you do with all these graphs and numbers? I mean, honestly, seriously, dude. But I think that what it all shows for me, Megan, is that patent procurement is really affected by the examiner type and how LexisNexis lays it out in terms of the green, yellow, and red examiners. I think is really, really important on how they do that. And so when considering patent prosecution strategies, we recommend determining the examiner's type and then using the examiner's individual stats to help make strategic prosecution decisions. And we believe this can both save on prosecution costs and increase the quality of your portfolio. So for our clients, we really like to use the information to proactively manage our clients' patent applications and help them build, like I said, cost-effective, high-quality, data-driven patent portfolios. And if you have a limited patent procurement budget, you need to be as efficient and cost-effective as possible. But you also need to develop a quality patent portfolio, because getting the patent is not the end of it; it's just the beginning. It's the beginning of a valuable right. And if you don't do it wisely ahead of time, we think it's all just a waste of time and money, and why even bother? Right. So if you can be both, cost effective and improve your patent portfolio, in our view, that's a total win-win situation. So by knowing the examiner type, this can help you achieve this, win-win situation. You can do things like strategize on prosecution tactics, craft responses to office actions, anticipate the time you need to obtain it, anticipate prosecution costs. Anyway, for our clients, we really like to use this information proactively to manage it. Like I said, we're driving towards high quality, cost-efficient, data-driven portfolios.
Yeah. I mean, my takeaway listening to you has been that certainly it's helpful to actually make strategic decisions, but I think it's maybe even more helpful just having transparency with your clients, so that everybody is on the same page, everybody has the same expectations. And secondly, that it allows you to even give advice to clients that maybe you couldn't before, or at least more informed advice than you're giving. So the last thing I'll say is that Michael is a prolific author. So I encourage you guys to check out some of the articles that he's already published on IP Watchdog and the IP portion of Law 360. He writes a lot about these topics. So please check these out. There are links in the slides that we'll distribute with the webinar. Otherwise, thank you everybody for attending today. If you have any other questions, specifically about Lexis, feel free to reach out. Thank you.
Thanks, Megan. Thanks, everyone. Appreciate it. Thank you for your time today.